No, sir. We have no.
Chair, I just want to apologize for my absence at yesterday's meeting.
Thank you. We got this, Senator. Thank you. And you're productively occupied. Sorry. Things have been changing a little bit fast around Parliament. What the MP is on. Just alert the MPs that are seeking 16 members of Parliament tomorrow in Parliament. Where the MPs on.
Yes, Chair.
Who's that now?
Right, Siblis.
Mr. Siblis.
Yes.
God, I'm going to call you old. No, not old, but reliably. You know what they say? I need you back in Parliament tomorrow.
Clear.
The printed copy we got from Gazette we got was wrongly printed this time. Elements of what was the changes made in the thought were not done. We have to have it tabled again, withdraw 2, table 3, so that Senate can debate, can take it on Friday. So I have to seek the presence of at least 16 members of Parliament tomorrow to get the table it. We'll own the table. So it's another quick meeting. I don't think there's anything else on the agenda at all this time.
Just start at 2 minutes, though.
2 minutes after 2, and we should be out by 15 minutes after 2.
I should be in my constituency tomorrow at some graduations.
Yes, this is why we took the break. What time is the graduation?
Graduation start at 11, but I will just call ahead of time so that I can be out of there and be in Parliament.
Thank you much, sir. You drive your turn ways, you don't drive too fast.
All right.
I have on them and seeing the list. That's a Turlo. No, that's not my time. So Williams again. Yes, well, is it the Parliament is in your constituency, so you're always there.
I hear you. I'm graduation tomorrow. What I didn't hear complete. What time tomorrow? At 2?
Yeah, sharp. It should last more than 50 minutes. We just have to retable the correct regulations.
No problem.
All right. And that incident down, I give you a call. And the incident downtown yesterday, it has been going well. But there's a little breakout yesterday, which I'll talk to you on the on. All right.
No problem, sir.
We can begin again at section 83, clause 83, suspension of firearm authorization. There's a major change here. I see introduced newly. 1, I notice in accordance with subsection 2, which is addition, and then it goes into it's capital. The board may on its own motion on a complaint made by any person. The next few words are deleted and it goes on for such reasonable period as the board considers appropriate, but which in any event shall not exceed 3 months. We go to A for public safety, R is removed, and B is introduced immediately after, as a result of a complaint made in respect of whether holder of is removed is a fit and proper person to be granted the authorization. Or and we go to C, which was B before, for any other cause. Then we do 2. The notice referencing subsection 1 shall be in the form prescribed, A, be in the form prescribed, stating that the authorization is suspended and requiring the holder to surrender the authorization and all firearms and ammunition to which the authorization relates to the authority no later than 3 days after the date of service of notice. That's the new form that was accepted.
Chairman?
Yes, Senator.
All right, I have a query. in B,
In
where you have, that is 83(1)B, which
Yes,
reads,
fit and
as a
proper
result
person.
of a complaint made in respect of whether the holder is a fit and proper person to be granted the authorization. Should we be using the term fit and proper person to be granted, or should we be using what we are seeing, a person, whether unfit or fit to be entrusted? Because that is the term that is used in respect to granting an authorization, is not so?
unfit to be trusted. I prefer that language.
It's just that the authorization is not under 58. The term is not, they're not using fit and proper, they're using unfit to be trusted. So,
I would accept. Thank you, Senator. And being men where we have fit and proper. Otherwise, you have recommended that by regulation, the Firearms Authority will have to give some more specifics.
no, well, in respect to that, I think, well, the term fit and proper is not being used in this bill. It is reading unfit to be entrusted.
Right. Thank you. We go across the page, chapter 7, containing in section 83(4). A person is aggrieved by a decision to suspend the firearm authorization may apply in writing to the review panel under section 86. Minister, the word minister deleted. 5, A, B, and 5 is deleted.
Excuse me, Chair.
Huh?
The SG has her hand raised.
Oh, SG, go ahead. SG, you have been told yet. How can you manage to be both places simultaneously?
My mic is muted.
Your mic is muted still. SG, your mic is muted. You can't release it. Oh, she has to release it. Yes, release it. Sorry, did you mute it? No. SG, your mic is muted. Mic, no mic. SG, we're still not hearing you. Hear it.
It's okay. I'll try to unmute her, sir, if it's not from her end. Maybe you could just continue, and then SG could come in when it's solved.
Love to hear comments. Let's see. Anybody else? Are we having any trouble anywhere else? No. Somebody can call out for me and let her know.
Sorry, can you hear me now?
Yes, all loud and clear. SG. Good to have you. I was asking you how come you managed to be in 2 places simultaneously.
No, yes, I was trying to speak, but it appears something went wrong on my end. No, I've made another arrangement. So I am in 2 places simultaneously because of the arrangement. Thank you, Chair. I just wanted to go back to the comment being made by Senator Sinclair, and just to say that fit and proper is used as it relates to members of the board, and there is a fit and proper criteria in one of the schedules. But when it says that the person is unfit to be entrusted, I still think that would need to be explained. You still run into the same problem, whether you say fit and proper or unfit to be entrusted. What does that mean? It's very vague. It's open to wide interpretation.
I got the impression, Senator, that the SG that Senator was trying to make it consistent with the previous reference.
No, I understand. Agreed. And there's consistency, but what does
but there need to be explanation, and I expect the same reasoning for fit and proper should be embodied somewhere. What you mean by fit to be trusted. Right?
Remember, yesterday we had accepted what Senator Sinclair said in terms of what he believed from the UK, that we have developed something in that form. That Senator Sinclair yesterday had recommended that we develop a scheme of things that would deem someone unfit to be entrusted, and he had referred us to the UK provision, which Minister had ordered that we look at in terms of developing a scheme that person would know and understand what factors are considered in determining
that proper and fit to be trusted. Unfit to be trusted.
Okay, so that would be presented at some time for all of us to review then. Okay, thank you.
And page 77 now is 5 was deleted, 4, 5 was deleted totally. 84, revocation of Firearm Authorization Board. 1A, deleted at the end is life certificate and firearm authorization is replaced by firearm authorization, which is consistent with what has been done ahead of the game in other areas. Section B, 3 continues, and the first 4, Romans 4 is deleted. So illegal possession or use of a firearm or ammunition, use of violence for which a fine or a term of imprisonment was imposed. That would read as 3. And then 4 would now be dangerous drugs for which a sentence of imprisonment for a term of 2 or more years was imposed. When we go to D, again, this has some addition. It will now read, the holder thereof is convicted of an offense involving domestic violence or against whom a protection order under the Domestic Violence Act has been issued when the period of 5 years immediately preceding the date on which the order comes to the attention of the board. It's 5 years adjudicator should not be qualified. We had agreed to this, but I'm asking the question because we have just had a case appeal, so turned down by the review panel for additional reasons. No, the gentleman did not declare that he had a domestic violence issue in his initial application. It was in fact 8 years. So he was not granted less for not being fulsome in the truth. But this 5 years adequate. I leave the no question. This is what we have here. Section 2.
Sorry, DTM, I had my hand up.
Oh, sorry, go ahead. It's already, sorry, go ahead.
That's fine. So the 5-year period is in relation to a protection order, but is there a period if there was a conviction?
No, there's no period on that one. Right. I would leave that you know. If you have a time period in domestic violence, you have to indicate some qualification like attendance to counseling and some.
No, I was wondering if the same 5-year would also apply or should apply. It doesn't know, but should it also apply if there was a conviction? So the 5-year could apply for both the conviction or where there's a protection order. Or if not, then perhaps consideration be given to some other time frame. Because right now, it's not, it appears as if once you have been convicted, then you're barred completely. Or I'm not sure then how to interpret it.
That's my inclination, but I'll be advised because there's a conviction for domestic violence. It means it got that far. Yeah. And conviction in domestic violence is not so easily done because there's always witness withdrawing and over a long time. It usually means that there's a severe element. And I've been trying to leave it out and if he has to get it, he has to appeal to the review panel. We'll then do a fulsome review, a judgment call made by the review panel, which is by definition of a level of, can advocate quite effectively. I leave that
Sorry,
at this.
sorry though, Chair. I don't think that you would have an appeal before the review tribunal, because if the law bars you, then the review tribunal can't go outside of what the law says.
But it's not barring you to say, order the office conviction.
Yes, the conviction seems like it's, if you have a conviction, that's it.
You don't get it at all. It's a revocation, revocation found authorized by the board. But it's a revocation, so they would have the right of appeal.
Right, so the review tribunal couldn't address this.
Huh?
So the review tribunal couldn't address this. It means your license would be canceled. It talks about a cancellation.
Right.
So it would be canceled and that's it.
No.
No?
Yeah, Minister, yeah, Shane Darling, FLA. Once a license, where any license is revoked, the person has a right to appeal to the review board, regardless of the circumstances. Because the person is appealing to the review board, and the circumstances may be that the person is appealing to the review board that my conviction was 15, 20 years ago. And I've been rehabilitated, reformed, and I have not had anything since then, and I can explain what had happened. And the review board, in considering the matter, may decide to issue. And they have.
Well, like, SG, if I can say that.
Sorry, I'm not completely
Let me ask
sold.
SG.
I'm not sold on that interpretation.
Yeah, I want to ask
because
you.
it's suggesting that the review board can go outside the power given in the law, because
Yeah,
the
I'm
law
saying.
is saying that you are barred once you have a conviction. The review
Yeah,
board
that's what I'm
can't
asking
go
you.
beyond it.
SG, what this is saying, I say the whole of the office convicted of an offense. It really means that you should not have the law is saying he is not entitled to a license again.
Exactly. It's a complete bar.
There has to be some qualification if he has to go to review. He has no appeal. Or he could go to court, and the court doesn't have to maintain the law.
And by the way, I think this is supposed to be dealing with cancellations. I know the word revocation is used even elsewhere, but I think this is
revocation. This aspect is revocation, but it would apply also to.
No, I'm sorry, DPM. Look back at 85.1. It says cancellation.
Yes, revocation.
So cancellation is can we have consistency in the use of the terms then, please?
Yeah, okay, when they go down to 85. All right. What I would do, let's not leave 84D. Would allow the 5 years to apply to both, and then the review panel would examine the case as they arise. All right. Just give instruct for the wording so the policy can instruct. Right.
Sorry, can I just get clarification whether we're looking at cancellation and revocation, or one or the other? Because I think there is an inconsistency in the use of the terminology.
The cancellation and revocation is actually two separate things.
I thought so. And if you look at 85.1, it speaks of cancellation, and then 85.2 speaks of revocation. I was looking at 85.1 and a comment was being made about revocation. So I just wanted there to be clarity on the use of the terminology, and perhaps then the marginal note would need to also be adjusted, unless I'm reading this wrong.
Just change it.
Revocation should not be 80%.
What's the difference? So
Sorry,
next
but
page.
85
remember, still cancellation.
cancellation and 85.2 does talk about the cancellation or the inconsistency.
Oh, my 85.2 talks about revocation. Sorry, the print I have has revocation in there.
There is a change. Circumstance in which firearm authorization may become void or may be cancelled.
It doesn't have revocation.
Oh, I'm sorry, I think it's 84. Oh, I see it's my error. I think it's I was mixing up 84 and 85. I'm sorry.
Okay, read for me now.
I'm sorry.
Okay, so
D.
So,
straightforward.
so the next change would have been at subclause 2D, just a change from license certificate or permit to firearm authorization for consistency. The other change at subclause 3 to include and given the reasons therefore at A, and at subclause 4 to include the words without reasonable excuse. So no reason who without reasonable excuse fails to surrender an authorization in accordance with the requirement under subsection 3 commits an offense. Subsection 5 is amended by removing the word minister and replacing with review panel. For clause 85, the marginal note has been changed to circumstances in which firearm authorization becomes void or may be cancelled. And 1D is deleted. 1D read in the case of the authorization that may be granted on subsection 4. So that has been deleted. And the paragraphs renumbered accordingly. For subsection 3, a new provision has been, for subsection, a new subsection 4 has now been included to say a firearm authorization granted in contravention of this act is null and void. That lines back up with the marginal note that was expanded. And a person who grants a firearm authorization in circumstances described in subsection 4 commits an offense and shall be liable for conviction therefore before, and we'll know instruct in relation to what to put for that provision. And that is in square brackets for discussion.
Sorry, DPM Chair, if I may, Marlene Aldred again, just to ask a question. When we say that something is granted in contravention of the act, would that also cover if there was a mistake, an error done? Because if it does, because an error could lead to something being granted in contravention of the act, would we want to criminalize someone who really made a mistake? So it would have been more like a tort, so to speak.
But SG, Rohan Richards here. The cancellation provision at 85 to correct evident errors.
C.
Is this in contravention? But wouldn't necessarily be in contraventions.
Section you're reading.
Sorry, in contravention means you did something that you weren't supposed to do. And I'm just saying that does not rule out mistake.
A mistake from the authority. Yeah,
which can happen.
CPC was about to comment. Let's see. Is that CPC?
Yes.
Go ahead.
Yes, thank you.
It says may cancel.
Penalty provision is in square brackets because having regard to the discussion before the committee on this point, there was some discussion about maybe dealing with this matter administratively rather than creating a criminal offense. So the committee needs to decide whether it wants to go that route or to criminalize the grant of a license in contravention of the act.
Oh, this was 85, what section?
4 and 5.
4 and 5.
Yeah. Shane Darling, FLA. Senator Golden Campbell had the discussion on this very point that where the legislation specifically prohibits an act, if the act is done, there was no sanction that comes with it, notwithstanding it was a prohibition in the legislation in of itself. Errors barring would be would not, I don't think an error, making an error in terms of in the legislation, as Mr. Richard stated, a cancellation, an error which is made, SG, can be cancelled, and it has been done from time to time in terms of errors. That is why the current legislation, the bill now has a cancellation provision, because prior to this bill, there's no cancellation provision that exists in the current legislation that on the Firearms Act.
Can you say what some of the errors might be?
I understand that point. My only issue is that someone who made an error could still be caught under the contravention provision. That's the issue that I'm raising. And I just want to know if that really is the intention.
Not very can criminalize it.
Yeah, MP Williams here through the chair.
Go ahead.
Yes, I tend to share the concern of Madam SG, because you know you can have a cancellation, but consequences can flow as a result of the whatever precipitated the cancellation could be an error or a mistake, genuine mistake on the part of an employee or an agent of the FLA. And so, in spite of the cancellation, you could still have penal consequences. So, you know, that's a little, that's an error that I'm concerned about.
Administratively. But I think it should be look back again at CPC's comment to make an administrative matter. SG that we could keep this issue of error on the administrative section rather than make it a law.
Yeah, that could be a way to resolve that issue.
Mr. Chairman, I don't know if this is a proper fix in terms of the drafting of it, but we could also look at just setting out 5 and accepting the grant in circumstances of an error. I'm not sure what is the tidiest way to do it, but I just wanted to support the SG in her comments, MP Williams and others who have indicated.
All right. What is happening, Mr. Richard? What is the proposal? We keep 4A and take out 5.
The idea that Senator Rowling was saying was to make an exception for evident errors on the floor.
All right, that sounds reasonable. I was a little bit distracted there. So, Senator,
like to clarify,
SG.
Chair?
Yeah, go ahead, Ms. Grant.
I get some clarification though. What about recklessness or careless negligence? Would that be included? Because then we would accept
no, I'm not considering
attributable to error, but not.
Oh, yeah, I guess yeah.
Attributable to negligence.
Well, by definition, that would not cover an error. But I gather you're raised in that way that that's a gray area in the context of definition. If somebody is negligent and just give it out, then that's an offense. I'm not, but who does it?
Can I, Mr. Chairman?
Yeah.
So can I just inquire?
Right.
We have missed it. When it is being suggested that a firearm authorization is granted in contravention of this act, and then it goes on in 5, a person who grants a firearm authorization in circumstances described in subsection 4 commits an offense. Well, probably I don't fully understand the system. The board is in the current dispensation. It is the board that grants a firearm permit, or what we call a firearm authorization, right? So the board grants a permit. That is correct, Mr. Darling?
Yes, yes. Yes,
And the board is made up of, well, for the granting, and you require what? 3 persons?
At least three signatures.
Members.
Yeah.
3 persons.
At least 3 include the chairman.
Okay. So can somebody explain to me how you would get a situation that 4 and 5 would arise? Just as an example. Pardon me?
Senator, the persons
Yes.
who signed the grant of it would have been the person who authorized it.
Okay.
I think this is seeking the correct, I don't know if it's the right way to do it, right family. The mischief that created the controversy last year, where board members intervened and approved licensing. So I don't know. The point there is, Senator, is that valid? Because I think at that time, I think 2 board members or any board member could sign off on it. Or 3, always 3.
So I'm just trying to appreciate how it is that, what is it that you say that the board would have considered and granted
Yeah, that's the mission.
authorization.
Thing is, yeah, the board, one board review rejects an application, and the next board picks up the same application before an appeal and approves it. Or a set of board members at one meeting defer it and the next one come and approve it.
I see.
Any 3 board members, but I think the new regulation will impact that anyway.
But where does it speak to that procedure, as so it would be in contravention of this act? So a person applies and the application is being considered, and then you said you're given in your example being deferred.
I have to reject it sometime in one case.
Right.
Rejected and before the appeal. It deferred or rejected. Both, I use both language.
Okay. So if it were rejected by a panel or board,
Right.
the board that considered it, and then another, without there being an appeal, they would have taken up the same application,
Yes,
which was
and approved it.
rejected.
Yeah.
But
There are 3 people.
But how could that then be a proper approval?
Well, it's a relevant question, but you remember the board meets, and it's 3 members of the board, a quorum. 3 members meet, reject an application, and before the person appeals, another 3 members meet and approve it. They call for the file and approve it.
How many persons are on the board?
5. So 1 person actually overlaps both and change their mind, but 2, the 2 were absent, come back and take the appeal and
all right. Okay, so the persons, if a board rejected and the communication of the rejection is made and they take up at the same application, well, it would be the same application, that was previously rejected. That could not be a proper application before the board.
You're correct.
You're correct, Senator, but it was done, and that's the message you're trying to
I
correct.
understand that, but then, so if we stop, all right?
That's what made the street.
So then four seems to be good to in that circumstance where a firearm authorization granted in contravention of this act, because then it would not have had a proper application before it. It would be null and void. And then we are saying no, that the person who grants a firearm authorization. So if we were to use, right?
Would do it commit an offense?
Oh boy. Oh boy. That I think that would require some other type of.
Senator Sinclair, I just want to explain, Shane Darling, I just explain for your benefit. So if the board who has the proper authority to issue, notwithstanding that the application was denied, whether 3 years before or by that very board, decides to approve it, the administration of the FLA could not stop the process of processing a license nonetheless and still issue to the individual for which a person acquired a license and a firearm, although it's in contravention of the act. So there's nothing to prevent the board.
Oh, what the law is saying.
All right,
no.
so I don't have a problem with four.
That was how it was, but what this law is saying, as Senator is pointing out, that firearm license issued by the board would be invalid. So you can't issue the firearm license.
Minister, what I'm saying, in the law, it can be null and void. About
this law now, yes, this is saying. I don't want to go back on the history.
No, what I'm saying is
Mr. Chairman,
null and void, except for challenge. It's not null and void. Senator, it's not null and void in and of itself because the law said it's null and void. It would have to be challenged for it to be declared null and void. It's not by administratively one to issue the license.
If I'm reading this right, Senator, please advise me. The law is saying here that if authorization granted in contravention of the act, it is null and void. You don't have to go to court for that.
Right.
So that's what the law is saying here.
Right. I don't have a problem. I don't have a problem with 4. But then
what 5 goes on to say is that the people should be charged with an offense, which is the license.
But who would be that person?
The members of the board.
But
Minister, good afternoon. May I?
Sure, go ahead, Ms.
This is Nadine Wilkins, Legal Reform Department. Sir, Senator said he didn't have a problem with 4, but quite honestly, I think the problem is 4, because it can't be just simply a firearm authorization that has been granted in contravention. It ought to be a firearm authorization that intentionally the person who granted it or persons would have done it knowing that it is an authorization that was in contravention. And that and it is upon, let us say that a firearm authorization is granted. As Mr. Darling was saying, the administrative processes will be undergone and the license may very well be issued and the individual, the license holder.
Okay, so the thing, 4 then should read a firearm authorization knowingly granted in contravention of the act. Would that be satisfactory?
Well, but in that case, Chair, that is when you would get into court proceedings to try and determine whether something was intentionally granted or not.
But that is an important policy point, CPC, right. and Chairman, I don't know if I'm a little confused about what the policy is intending to achieve here, because well, if I could just say,
go ahead.
I am not. This is a catch-all prohibition, right? And I don't know why it is necessary for us to have this sort of broad catch-all prohibition when we have specific duties and obligations in the Act for which offenses can be created and in many instances have been. So I don't know why we've done it this way, and I would wish to hear what the thinking is.
As I said, the mischief they're trying to correct, that will help more. It's simple that it is known that board members who do not attend a meeting have been known to go to the authority when they hear, by the way, that particular license is not granted by the last meeting, which they did not attend, invite one member who might be pliable to that next board meeting and authorize the granting of the firearm license. And once the board properly constituted grants a license, the authority or the administration is obligated to so grant. And that was how a number of individuals who did not merit the award got their license. So the issue is, the issue is whether the new regulations that outline the new law will prevent that happening. And if not, how do you correct that mischief? I think otherwise than this.
Mr. Chairman, why is with the how you have outlined, you have explained it. So that's why I don't have a problem with the bill, including the subsection 4. We have a problem because the granting of the permit, which would be done in contravention of the act, because that panel or board would not have had a proper application before it because it was previously rejected, right?
Right.
So it's either the person would have had to appeal or they would have had to reapply in the specified time. So if the board came up on the second approach and by whatever means gave the approval, that approval would be null and void because it is it was improperly before the board.
Right. So
I don't have a problem with 4. No, the issue that I have with 5 is that, as I understand from Mr. Darling, it is not one person who is granting the firearm authorization. It is 3 persons at minimum.
Right. Right.
At least one of those persons will be culpable because they would know what they would have wanted to achieve. The other 2 persons may have been innocently there, not realizing that it was rejected, right? It is possible.
No, Senator Shane Darling again. Let me explain.
Yes.
Just for the benefit of the.
Continue, Senator Sinclair.
So when you say a person who grants a firearm authorization, it is not one person. It is at least 3 persons who would grant a firearm authorization.
So
you said 3 persons have to sign it.
Yeah, shouldn't there be some unanimity?
So but one person may be the person who is a person.
Well, are you suggesting we should?
So I don't have a problem with 4, but 5 I think is something that.
Actually, say the members of the board who grants the authorization would then be committing an offense and be fined X amount. I remove from the board.
Mr. MP Williams here. Mr. Chair, through the chair.
All right. I have Ms. SG to follow and CPC. So finish up, Mr. Sinclair.
No, so that seems as if it would warrant a different type of approach.
Yeah, I'm thinking.
I mean, it must be some amount of what you would say, corruption or something there, because it's not one person that is granting the firearm authorization.
I think
firearm authorization cannot be granted by one person. So either the wording is wrong, either the wording here is wrong. A person who grants a firearm authorization, one person cannot do it.
No.
So unless you want to say all 3 persons were participants in the whole process.
But isn't there some power in the minister to revoke the board?
I'm coming to that, Mr. Williams, but let me hear what SG and CPC has to say. SG, your hand is up, or it was us?
No, sorry. If it's up, let me take it down. No, sorry.
Right.
No.
CPC, Ms. Grant?
Right. So person used in this sense would include an association or a group of persons based on the definition of Person in Interpretation Act. So the person there would capture a body such as a board.
Yes, I understand that, you know, I understand that, Ms. Grant, but what I'm saying, in a real situation, as I understood, that's why I asked for the example, and the example was given, that a board met, 3 persons met on one occasion, and they rejected an application was rejected.
File.
All right, out of the 5 persons. So 3 would have met. You have a scenario, it comes up again on another occasion, 1 person is present and 2 other board members who were not previously present. And they would have considered the application, the improper application, and approved it. Those 2 persons who came in, would they have known about the previous rejection? Is it, I don't know how.
That's why they came in.
I don't, pardon me?
They would have known because they'd have to inquire to get knowledge of it, but it would not go back to the board unless they inquire, ask somebody seeks to bring it to the attention of the board.
I'm just trying to understand the process. I'm just trying to understand the process.
Once it is rejected, the administration is required to don't inform the member that it is rejected. There's a time span between that rejection and the administration sending it out. The mischief is used that a board member will come in before that letter is sent out, ask for a delay, and then ask for the file again.
Right. So is it noted that everybody who comes into that second look at this improper application would see something to say that this application
They get the same file. They get the same file.
And the file would have, say, for example, rejected written somewhere that everybody would be able to see. Rejected on the application. It
should have, but what they will always have is the investigation that allowed for the rejection in the first place. They have a complete investigation in the file. Even if the ministry document the detail of the previous board meeting in the requisite detail, all the information that was there to cause a rejection would still be there. Unless somebody, which should then implicate the other person, remove anything from the file.
All right. Got you.
Yeah, it's an act of corruption. I think this is why it was suggested that there should be an offense. I think the mention by Minister Williams that should also include that those board members are removed from the board and be held unfit based on the Public Management Act to sit on any further board.
Minister? It haven't been so explained. I suppose I do have a problem with it, and they can establish that with the evidence at the appropriate place. So
Minister Nadine Wilkins again, I want to bring your attention to paragraph 14 of the 3rd schedule, where immunity is granted to members of the board acting bona fide.
Yeah, but with this timeline when the board,
why, if you want to criminalize a member of the board who may be involved in the grant of a firearm authorization, which is in contravention, it would in fact require intent, because anyone acting bona fide would have been protected by paragraph 14.
Oh, well, no, I understand that, Ms. Wilkins. I say knowingly granted. I don't know what the CPC's comment on that. But in terms of 5, the person would have to do it by design, because the file would have been removed from the list of files to go to the board, and being prepared for the required correspondence to the applicant, being prepared to be sent out, that they will not be granted it. So whoever takes it back to the board with someone who's aware, stop sending out the dispatch of the required correspondence, ask for the file to be brought back when they're present, and approve the license. It's a distinct act of, it cannot be an accidental happening, or one that happens unknowingly.
Yeah.
It is by design, by definition.
Mr. Chairman.
I think the law.
Mr. Chair, MP Williams here. My time?
Yeah, go ahead.
Well, the hypothetical case are the circumstances that were set out earlier by member Sinclair, member Sinclair, where a member who wasn't present at the previous hearing or the previous sitting where the authorization was refused convenes a second meeting. My question is that when that second meeting is convened by that person who was absent previously, the persons who are on the second, sitting on the board at the second meeting, wouldn't those persons, isn't it reasonable to infer that those persons would have been members of the previous sitting, who would have taken part in the previous sitting and would have had knowledge, knowledge of the previous refusal? I mean, wouldn't it be, isn't it a given that they would have known that there was a previous refusal? This member was absent, a new board is convened, we are now present here, and we are now here reversing our decision, our previous decision at whose behest?
Oh, well,
I'm trying to understand.
The law doesn't allow for that, Mr. Williams. It is Member Williams.
Yes.
The law allows that once you're rejected, you apply to the review panel. For a board member to then at a convene meeting, ask back for the file is not in line with the outline of the law in keeping, because once it's rejected, it's rejected.
No, I understand that,
so that means the person who called back for the file is by design asking for a file for the board.
I'm aware of that, but what I'm saying, that person cannot independently and solely.
No, well, that's what was said.
Authorization.
That's what I explained, that 5, the person means 1 or 2 are persons, those associated, or 3, whatever they associate there. So that covers the.
So the point I'm getting at, the point I'm getting at, Chairman, there has to be a quorum, so to speak, to grant that authorization, correct?
Yeah, there is, and it was a quorum. It was a fully conceded board of 3 that did, but you don't have another.
Yes. So I'm going to and what I'm trying to get at is SG's concern about bona fide, a person who sits bona fide.
That's legal reform. I'm saying that a legal reform is concerned is right, looked at superficially, but the fact is for the file to come back to that board, it means somebody have to do it by design. It can't be brought back there bona fide. And once the take out is out. So it would require someone.
So I'm saying, yes, Mr. Chair. So what I'm saying is that persons who sit on the second, at the second sitting or hearing, or to determine those persons, naturally, isn't reasonable to infer that they would have some animus because they were a part of the previous.
Yes, that's the object of this regulation.
Okay. Right. So in other words, my question then is, how could they claim to be bona fide?
That's what I'm saying too.
Yeah, it's gonna be
there can be no bona fide in the second case.
You weren't aware because obviously you were present when this refusal was granted and the grounds were stated for the refusal, and now it's back before you on the behest of another absent member.
On your request. It's back before you on your request.
On your request.
Yes. On whose request, Mr. Chairman?
Request. Is it the member was absent before?
One of the board members.
Yes. So my concern, or what I'm getting at, is that it is very difficult at that point, at the second meeting, for a member to say, I'm a bona fide representative, I'm here in a bona fide capacity.
Senator Golding, which was asking, you're asking something, Senator Golding.
Chairman, I am not at all supportive of this type of an offense. I don't like the broad scope offense, but let me see if I can direct the committee to where I think the issue really lies. We are put this provision in the midst of a section that deals with the granting of firearm authorizations. But our discussion is centering around the corrupt behavior and practices of a board, an errant board that does something in contravention of the act. And so it is my humble opinion that the matter ought really properly to reside in the provisions dealing with the functions and powers of board members. That's one. And two, that in relation to the criminalization of actions leading to the grant of a firearm authorization by the board, that those actions be specified in law, to say simply that someone is subject to criminal penalty because they have granted an authorization in contravention of this act, meaning the entire act, is really an absence of looking at the policy position that you're trying to legislate for. It really is. So what is the policy? What are those actions that you want to say are criminal actions? Because
I understand the criminal actions are defined as well, but the board technically is functioning at policy level. That's one, and the board represents the government.
Yeah, but Chairman, with all due respect, those examples that were raised, I sit on boards, and I cannot imagine on what authority I could bring something back to the board that the board had already made a decision about.
That's the issue, Senator, which you're trying to correct. Hold on a bit, Senator. That's the mischief we're trying to exact mischief.
But they don't do that.
No, hold a little bit. I can understand. I cannot hold a board liable if they get a formal request, formal minutes, formal presentation to the board, and you're part of it, and you make a decision, and it's minutes that it do for review or so forth. This FLA is the authorizing body. It's an authority,
right,
of support. And the act that is being criminalized is no act that cannot be done by the board. Nobody.
Yes, Chairman, but we have not. Chairman, I know you're responding.
I'm not saying that. I'm trying to clarify so I can understand.
I don't think I have properly put my point to you. So
what give me a chance. Allow me to clarify what I'm saying, so and I want to hear what you have to say.
Go ahead.
On the board member can take this action. Nobody else can.
What is this action?
Action to pull a file that has been rejected and bring it back to the member. The administration cannot do that.
Okay, Chair, can we hold right there just on that point? Because that's the point I'm not understanding. I am not understanding if a decision has been made, how any member of the authority would then be pulling a file to bring back something before the authority that the authority has already made a decision about without anything more. It is tantamount to a court wanting to reverse its own decision. Yes, and that's not, but that is not, but if that is what a board is doing, Chair, and so now I move on from that point that you said, if that is what a board is doing, then that is the action that we must be talking about, and talking about whether or not we want to criminalize it, not just the broad grant of authorization in contravention of the act, but if any board member acts to reverse its own decision without any application before it, then the board member acts in contravention of the act. That is what we should be talking about, because that is what you want to criminalize. That's the mischief you're seeking to fix.
In the most cartel case.
What's that? Who's speaking?
I'm not sure.
So that's
where I would like us to look at.
No, the legal reforms is that we should put knowingly granting contravention of the act. as far as the board is referring to, but I'm saying, bear in mind, and here I'm not, well, I just want to make sure we correct what the mischief we are trying to approve. The board is an authority that grants authorization for firearm use for firearm. Because the structure of the board, because you could maybe change this differently. If I put what you have suggested and then Senator, I think we could just change the quorum. What happens in practice, because the quorum is 3 of 5. They meet regularly because there are a lot of applications. Any 3 turns up, and I think we have also put this out that the chairman should be there, but any 3 turns up can have a meeting, the public convened board meeting. So if on Wednesday, the chairman turns up with his 3 members, approve a number of licenses, reject 2 or 3 firearm licenses. The 2 who are not there is made aware that a particular license was rejected. They turn on Friday and invite a member from the other 3 who they think they can in legal to support them. And approve a license, ask back for the file from the executive officer who must give them this, a board member. So I want to see file X. They look at the file, it is rejected. The same investigator, they say, no, I'm going to approve it. That's the process, that's the actual process that happens. How do I criminalize and reverse that particular mischief? And imagine how the board, yes, that's what the board, because technically it's the 2 members who are not there. They are the board members. They ask for the file. So it's not like, in this case, the person or the board is where the reverse of person, it is not individuals. Still constitute the court, but they're going to reverse their own decision.
But Chair, if 2 board members were absent, what business is it of theirs to be going to review the decision of the other 3 board members?
That's exactly the problem, Ms. Go. I'm Senator.
Yes, but Chair, what I'm saying is we're not attacking that problem with this provision. We're not.
Minister, can I just add something? Minister,
the Senator is saying that the provision does not. Hold on a second, Shane. Correct the mischief. I'd love to hear from the SG and the CPC. It's a technical issue. The case is out. There's nothing more to say that I've said about the issue. It's how do I correct that mischief? That's all they're asking. The Senator is saying that this law does not correct the mischief. I need the technical team to tell me whether it does or not. Yeah, so SG, go ahead.
Yeah, yes, I've had my hand up because I am persuaded by Senator Golding. So I will start with rule of law. Rule of law says an offense must be clear, precise, specific. What is before us is not addressing the specific issue. And it is true, when we say in contravention of this act, it's wide, and this is the reason I even had my concern about how wide it would be, that it would even cover persons who had perhaps made a genuine mistake. If you consider what Senator Golden Campbell has proposed, which would definitely go to the heart of the issue, because that's how you address law. You look at the issue, you look to see whether it's addressed or not, and then you look to see how you can address it. And you have pointed out the issue. Senator Golden Campbell has indicated a response to that issue. And I think that perhaps that's what you should be looking at, to craft an offense to address that specific issue.
I have to be advised, that's what I'm asking.
Right, so instead of this whole thing about, so I'm not even sure it would be for the CPC to explain where that provision would go, if it's really this provision, if it's this section, this clause or another clause, but it would be specific to address the issue that where a decision has already been taken and a member decides to try to reopen that matter, you're criminalizing that, because that is what happens, if 3 members already took a decision of the board has already been taken, the board is now functus, which means the board has no authority to act again. So 2 members can no longer, quote unquote, reopen the matter because the matter has already been decided. So if it is that you want to criminalize that, then you need to be specific about that issue and create the offense. Make it an offense and create the penalty.
So how do I structure that? As a CPC, do you wish to comment?
Yes, thank you, Chair, because this provision was never intended to address that specific point. It arose out of a discussion that was had before the committee before, where this was the substance of the provision that was recommended. But in terms of the actual specific case that was given, right now the provisions governing the operations of the board would allow for a scenario like that because it allows the board to regulate its own proceedings aside from specifying what the quorum is. So as long as the quorum is met, decision of the board to reopen a case could be perfectly, there's nothing currently in the bill that would prevent that. If that is a specific mischief to be addressed, there would need to be some provisions in the schedule then specifying that once the board has arrived at a decision using a particular quorum of membership, if the matter is to be reopened, then it should be with that same same panel, same membership reopening the decision. It would have to be with their consent. And I think that is how that would have to be dealt with. And anything outside of that then would render the particular decision null and void.
That should be in the schedule.
Yeah, well, Mr. Chair, MP Williams here, in relation to the schedule, with your permission, sir.
Sure.
The third schedule, I'm looking at 12.1D, and it's 12.1 essentially addresses the issue of the revocation, the question of the revocation of appointments by the minister.
No, that's the ministers that when the board misbehaves, we'll file it.
Section 12.1D. If you look at section 12.1D, it says the minister may at any time revoke the appointment of a member of the board if the member engages in any activity that can reasonably be considered prejudicial to the interests.
Yes, and we will do that. Having done that, I'll do it. Be criticized for the rest of life. I've done that before.
No, but I'm saying, and my approach may be a little simplistic, but this is my view of this specific allegation against the board where it occurs, is that there is some residual, there is power in the minister in those circumstances where there is sufficient evidence of that kind of nefarious or activity for the minister to act in relation to the appointment of that member.
No, that is not an issue,
yes.
What we are looking at when the board, and bear in mind, if it doesn't come to the attention of the minister, he can't do anything. The object is to, and I go back, I think what CP said is right from the schedule, that if a board by design, members, seeks to reverse one decision, to undermine the decision of the board, members of the board, then that's a mischief you're trying to correct. Charge them. Even if you're going to fire them, the ones he's charged, I'm going to fire them anyway. But they would be charged for mischief, for an offense. But they set out to break the law. And therefore, if you have to allow room for it to happen, of course, you can. It has to be the same members who were there before, have additional information to make a change. But 2 members were not there. You have to assume they are seeking to undermine to breach the law and charge of an offense. I think if that is placed on the schedule, is this clause have any value in terms of action? Do we delete the whole clause 4 and 5? Is this the only mischief we're trying to correct, or the other way that legal reforms suggested that members will
yes, and that's the point I was making, Mr. Chair. That if that was a mischief, I was thinking that there is that residual power in the minister to address.
Yeah, but I'm saying, remember, it has to be brought to the attention, but the law is going further. Anybody who seeks to undermine the credibility of the board will be fine. Now, what we charge for the offense is different. We can say a fine of $1 million or 30 days in jail, the board members, none of the board members are going to be in jail for even 1 day. That's you may want to structure it in a parish court. So they are really just saying they'll be fired. The minister will be required to fire them for ethical reasons, but they'll still be fined for breaching the law. So
Okay, I see.
I think I would support, am I right, SG, CPC, Mr. Richards, that it be put in the schedule. I'm asking though, is 4 still have any value? I can see 5 going, but is 4 have any value at all in this process with the qualification required by legal reform? SG, would you have gone to that a firearm authorization granted, knowingly granted in contravention of the act is null and void? Would that statement have any value? Now we have corrected the particular mischief of which I am concerned. Senator Golding and Charles, would that have any value in this case?
Chair, can I put something to you on that point? I'm sorry, excuse me. If we're holding to the knowingly language, yes?
I'm asking because I've accepted that, therefore, the criminalization of the deliberate corrupt act will be put in the schedule as recommended by CPC, and she'll be given such instructions.
Right.
Is there still any value of the first, that Lily's 5 altogether, but is there any value in having not a reasonable catch-all, not a catch-all, as I said, who has a firearm authorization knowingly granted in contravention of the act is null and void? Would that have any value in this section?
I still have a nervousness about this kind of broad scope, Chair, and the reason is
I'm asking advice to them.
If you're granting it in if you're saying it's null and void, the authorization is null and void, then it's null and void at which point? At the point that the grant, the contravening grant is determined, discovered?
It's up to be.
And how does that process engage? Because it would seem to me, just on reading this, that once it is granted in contravention of the act, the authorization is null and void. So I'm walking out with an authorization that I think is an authorization, but it's actually not an authorization because the act makes it null and void because of the circumstances surrounding its grant.
Yeah, but in other words, you don't have the license because it was granted, but in contravention. Somebody reports it. It has to be reported. That's come to the attention of the executive of the
right. And this is assuming that I am a part of this scheme to have had this license granted, because that may not necessarily be the case either. Right? But let us assume that. So then I'm walking around with an illegal firearm. Essentially.
Pretended, but not okay, it was properly granted, but when it's discovered that they'll have to withdraw it. They're not properly awarded. Yes, you do walk very legal firearm against null and void.
CPC has her hand up, Chair. I suspect she's trying to assist.
Yes,
yes. Well, I'm sharing Member Golding Campbell's concerns, and I think it would be worse even by the introduction of the word knowingly, because then you would have a situation where there's something there to be proved. The license holder would be in a state of uncertainty during that time when all of this is being settled as to whether somebody knowingly granted the authorization in contravention of the act. So there's a lot of uncertainty. I don't think that the provision by itself would stand like this. It would at the very least need some supporting provisions protecting the license holder in respect of any actions taken in reliance.
The license
was valid.
The license holder has been protected.
If it was just a specific mischief that can be solved another way, then I would think that we would be better off.
Well, I'm taking your suggestion for the specific mischief I raised. which is where the board member deliberately intervenes and contravene the original findings of the formerly convened board. But I was just asking this if there's other circumstances. And for example, Senator Golding is asking if the person how could come to the attention, Senator, a person who was investigated by, and is always by the NIB and the other relevant authorities in giving fit and proper. And they suddenly see this person walking with a firearm and he has a license. Then they're going to investigate how they get that license. So I just wondered where that fits in that particular situation. You see, we're at the pinnacle where the board is the accountable body. So I've been researched by NIB, MOCA, and the investigators. There's a recommendation that I am not fit and proper because I had a conviction last year for beating up a girlfriend, a domestic issue, which prohibits them getting the firearm at that point. And within a 2-year period, if NIB inadvertently sees the man the firearm, he goes and checks his records and this was there. Then it's the word of investigation, or MOCA, somebody reports to MOCA that there's some corrupt practice going on at NIB, and these are some of the things happening, and they will investigate. So that is how it could come into the notice of the board. Is this rewritten? Would this be the kind of clause to correct it, or do we need another clause? That's all. I'm just glad the person, where this concerned, the person was clearing up with someone who was deserving a firearm anyway, but they still couldn't charge him with illegal possession, given that he was given that.
But Chair, that would be something that would could be addressed by the provisions that allow for revocation or cancellation. Because in the event that it's discovered that the license shouldn't have been granted because one of the conditions to be fulfilled, then it could be revoked or cancelled. In that case, the issue of something having been illegal during when the defect was not discovered wouldn't arise. The license would have been valid up until the time of the revocation or the cancellation.
All right, so in reality, these 4 and 5 should be deleted and the proposed clause in the schedule inserted. Richard, you understand that, no? All right, you give that. Okay.
Sorry, before you delete it quickly, Mr. Chairman.
Yeah.
Is it all right if a person by some oversight is, and let us call it, should I say error? Because something that could have been known was not known, and everything appeared in satisfaction of the board and compliance with the act. Those are different scenarios than one in which there is an improper application before a board. And that's why I say 4, in the scenario that you created, when we're asked for a scenario that would satisfy subsection 4, wouldn't that be a null and void situation as against just a situation where it is properly issued, but something was discovered that we are going to now act on to revoke?
All right. Before I said that, I asked the question, Senator, and what the CPC is saying that we should deal with that under that the revocation will deal with that, because whether by error or by unknowing design, so to speak, so you don't have to read the charge, but the person got the firearm license.
We're just going to with all of them as revocations.
It's a revocation.
Regardless. All right.
All right. Part 6, appeals. And this generally appeal may be made to the review panel, replace the word minister throughout, and granting a refusal of firearm authorized other than a firearm manufacturer's license. I mean, the manufacturer's license follow different routing. So that is added there. It has, I think that still retains the minister and cabinet levels involvement. And E is deleted. E is deleted. Fifth schedule 2. The provision of the fifth schedule shall have effect in relation to the constitution of the review panel. And then we go to review panel and the deletion of fifth schedule at that point. 871, upon appeal under section 86 of the delete, the minister shall appoint in accordance. It says upon under section 86, the review panel shall confirm the decision of the board and issue such direction that the review panel considers fit to give hereto. The next paragraph is deleted and a new paragraph inserted. Refer the matter back to the board for a fresh decision on the matter or make such other decision in respect of the matter as the review panel considers fit. And then it continues and shall in writing within 180 days after the appeal is made, notify the board and the appellant accordingly.
Excuse me, Mr. Chairman.
Sure.
B, refer the matter back to the board for first decision on the matter.
Yeah.
So after the board revokes and you appeal, you are saying that the review panel should be allowed to refer the matter back to the board for fresh.
Circumstances like they have been instructed to do further investigation. For example, where when the review comes up, if the person changed home, that's a common one. They move from where they were and they feel this house is safer. Then the review panel will instruct the authority to do a further investigation of the circumstances to confirm that the house is now safe to contain a firearm. That's the usual one. There could be other things, but that's a common one. So that the board has, the panel have the option of upholding the board and issuing new directions, which is either to do further investigation and reassess, or in fact instruct the board to grant the license despite of their original rejection. The board, the review panel retains all three options: uphold, reinvestigate, or instruct to grant license.
All right, but
there's all the investigation, not just to look at the board. They have been given specific instructions by the review panel in terms of reinvestigating, and it has in fact gone well in most cases.
Yes, but I'm just saying refer the matter back to the board. Just
you should be able qualified.
Yeah, well, that is probably what I'm looking at.
Yes.
I don't know if it can be.
Depend on the drafts or LRB to tell me how to reword that, whether it is a back to the board for further investigation or fresh investigation or a new look, something. I remember the panel can take up to, we have changed this now from 90 days to 180 days. So circumstances could have changed and you ask them to review. I'd be advised what language is used here to show that it's not just a return for a fresh look, but with instructions.
Well, I suppose thought can be given to it, but that is the concern that I had as to how it was just.
So Richard, I note that some changes put in there to qualify, refer back to the board in order that an investigation be carried, a new investigation be done. I've been advised by the drafters.
Before we move on from 87, Minister, I think the shall should really be may.
Here.
In 1. So upon appeal on a section,
yes,
the review panel may instead of shall.
May.
Right.
May do what?
Yes.
Well, no, I don't agree because the review panel has to take one of those
The
actions.
decisions.
So, yes, so the or there would have governed the
Yeah.
alternatives.
They must act.
Yes.
I'm with you, Ms. Grant. The board must make a decision and that decision communicated to the relevant person, citizen in due course. If they shall, we can keep the year. All right. The R's cover that. One of three decision. Confirm decision or ask for a fresh investigation or instruct the board to grant the license. That's it. 2, time allowed for giving any notification under subsection 1 may be extended by the agreement of the parties in brackets. Agreement of the parties if circumstances so warrant. 6 months, but I don't think it's unreasonable. Just in communication with the parties and they.
I'm not sure about the agreement of the parties, so I'm not sure the thinking behind the
But you want to
parties'
inform
agreement.
the gentleman and you tell him you need 6 months, you will reply to him in 3 months' time.
And what if the gentleman does not agree?
Well, it takes that means that you get a refusal because they have come to the investigation.
I mean, I think the panel should just extend the time
No,
period.
I think you should be informed.
No, if the circumstances warrant, but the person.
Yeah, but he still informed the
Yeah.
individual. I said, look, I think I should hear no. Then when they don't think I get to no.
Yeah, so I think the agreement of the parties what is
No, I like the idea of agreement of the parties. I don't know what the lawyers do. In other words, the opposite, if the candidate who is until proven otherwise a law-abiding citizen in need of a firearm says, look, I think I deserve a firearm license, and you say, yeah, I'm not done completing my review, you can take another 3 months, but I need to know by then. And if the review panel says they want 3 months, similarly, they agree. I don't think anything is unreasonable about that. Members, I think the interaction in the modern world between those being served and those who are serving is becoming increasing interactive, and we might as well accept it.
So I don't know, Minister, that when a court is making a decision on a matter.
I know that this is not a court.
It's based on how we're doing it. So I'm just trying to liken what we're doing, what will be happening. So
what I'm asking, Mr. Policy-wise, is that the applicants should be engaged.
Right.
One day the variation of what they're doing.
Right.
What they're saying, just tell them if the panel wants 3 months, tell them without any.
If the circumstances so warrant.
If they want.
Right. So providing reasons for why the circumstances so warrant, why the extension is being suggested.
If you do it that way, you'll have to give them a limited time. If they need a further 90 days.
As long as it doesn't go beyond that further.
Yeah.
Well, 90 is a little long, but 30 days maybe.
All right. I could live with that. This last thought, was this deleted out?
I think it should have been deleted. I think
yes.
3 and 4 should be deleted. So that was an error.
The exception for the manufacturers is already there, which is the one where the executives still have a say in the manufacturer license. That's cleared in 86A. So there is no need in terms of a regular firearm license. Only thing is, should we have a clause, SC, that allows the person to get judicial review of this or choose, or is it automatic or implied by natural justice?
That needs to be said.
Sorry, DPM, can you just repeat that?
3 and 4, which was where the minister had a say in after the review panel came in, which usually act on behalf of the review panel. Should it now be, does it need to be specified that the person now can only have a further appeal by going to the judiciary?
Oh, no, you don't need to specify that in law because they always have a right to go to the full court to review a quasi-judicial or a decision coming from like a minister, an appeal.
Okay.
It doesn't have to be specified.
National Firearms Registry.
Sorry, before we move on from the review panel, Mr. Chairman, my question is, does the and it's probably, I would seek the guidance of the sergeant on this, whether it should be specifically stated that at the review stage by the review panel is the applicant entitled to be heard.
Now that is a final court of appeal as well. That's a good question.
But so the natural justice principles say that the person must be heard, they have to be heard.
Can we stop right? Yes.
But there's nothing, in fact, it can enhance the draft if it's put in specifically, but even if it's not there, the applicant does have the right to be heard. I think the issue normally is whether the person would be heard on paper, in writing, or orally. And that also can be specifically put, because generally a person doesn't have to be heard orally, but they must be given the opportunity to be heard, whether or not it's in the legislation. But I agree that it would enhance the legislation if it is specifically stated.
And I raised it because of a comment that came to me in relation to matters that have been at that body. And I'm certain I could not have heard properly, Mr. Darling.
SG, you're saying that it will enhance the bill if you put it in. Right, SG?
Yes, Chair and members, it would definitely enhance the bill if it is specifically stated.
Well, I would also this because I said you no longer have any reference to the executive. So I think that the panel should allow, if especially in a rejection, if the person wishes to appear or have someone submit appropriate appeal by his lawyer, then it should be done. I know you structure the word, but I think it should be in there.
All right, let me tell you what the practical experience has been, and that's why I'm raising it. Application, an appeal is made. Remember, the board does not have to give you any details as to, at least up to now, they have not had to, they don't have to give details as to why they would have taken a particular action for revocation, or as the case may be. And so the applicant is almost making his appeal in a blind. He does not know necessarily all that he has to respond to. So he writes up a form and makes a submission, just answering the specific thing that may have come to him. Oh, you're not considered a person to be entrusted with a firearm. What is their response going to be? Yes, I am a person who can be entrusted with a firearm. He can't say anything else because he does not know why they may have said that. And then the board will have an opportunity to send whatever information it has to the review panel. But then the review panel does not say anything to the applicant, and the applicant only receives communication to say that your appeal has been refused, and he knows nothing more. Never given any complete opportunity to respond or to make submissions specific to whatever the board may have had while they sent out a revocation. that has been the experience that many persons have had. And so I'm just trying to see how it is that we can correct that situation so that there is
I'm
fairness.
accepting a proposal from the SGR, the suggestion.
Chair, though, I'm so sorry to interrupt, but if I may, in the schedule, it says that the tribunal, oh Lord, sorry. Yes, the tribunal regulates its own proceedings. So usually what we expect is that they would regulate proceedings in such a way that they would have their rules and persons who are approaching them would know the rules. However, you could go further. In light of the difficulties that have been experienced, they could be mandated to gazette their rules, because we do have tribunals, for instance, that do that, where they set out all their rules and they gazette them. So one such tribunal would be the one established under the Access to Information Act. So I'm just throwing it out there for consideration.
I would suggest that line of development, SG, because if the review panel become a final review panel and in a very sensitive issue. So it may be appropriate that that is done. The results. Okay. So that should satisfy the request, Senator Singh here.
That yes, sounds that way, Mr. Chair.
It sounds should have been done before, really. All right, that's they removed this words 3 and 4. Yes. I'm going to National Firearms Registry. Director, National Firearms Registry 2B. This is an addition. Providing information system with criminal and other investigation. 83, there have been no changes suggested. 84, also good. 85, page 85, same. 89, functional registrar. For 5A, in this section, yes, is an addition. A foreign law enforcement agency means an entity having investigative or prosecutorial functions under the territory in relation to criminal offenses and includes an association of such entities. You have B.
I'm sorry, Chair, why is that being inserted?
I need to remind it, but I think you have to do this.
Because we had raised a concern about this provision at another place. And so from the perspective of the chambers, I'd just like to understand why these provisions are being reinserted when we already had expressed some concerns about them.
So the clause subsection 6, 7, and 8 on the next page. This is outlined.
6 and 7.
Yes, I've seen 6, 7, 8, and you will recall that these chambers raised some concerns about these provisions.
Yes, the question
concerns would remain.
I think there has to be some protocol for this kind of information.
We're concerned about how this would interrelate with the MACMA regime. Mutual Assistance Criminal Matters Act and the regime under that legislation. And why we would need to be trying to, is it that we're putting in a different regime? I'm not clear on what we're doing here. We have to be very careful about when we start to talk about foreign law enforcement. So would really need to understand the rationale for this, what the mischief is, what we're trying to achieve, and if this is the way we have to achieve it.
I'll ask Terry to explain the default, but before you comment, I think there will have to be some acceptance of a level of exchange, because ballistic information individuals and terrorism, as well as criminals, has to be exchanged freely based on whatever treaty organization we have.
Right, you're correct, Minister, because we had made
and then before I go a bit, for the honest citizen, which is one of my bird to ensure honest citizens get there, have a minimum level of service. When you have someone like we have had recently in the airport in Montego Bay who inadvertently carry a firearm through, if we can get the information real time, then there's no charge, there's no issue. We move on. If they have to be charged, then they have to spend some time in jail and time and all that kind of. So information exchange, but I'll be advised on the legal details. Go ahead.
I think you said it perfectly, Minister, in terms of the requested for an expansion of the provision to allow for the sharing of information with law enforcement agents in other jurisdictions, similar to what happens on the FID as well as on the MOFA. And the safeguards are so included in the subsequent clauses.
See, on the all right.
Sorry, Chair, I'm going to ask for the AG's chambers to be given time to review this provision.
Yeah, but I said the exchange, if you allow to look at the protocol, because the exchange is crucial for the functioning of the registry. There has to be interchange, real-time interchange of information. The protocol will have to be ensured it satisfies the data regime, but we have to have real-time information. That's a must if we have to look at the amending other section of law for it to work effectively. All right, so we'll await your review. Still, but it remains as is for now. For the stop and search.
Chair, I don't know if your members have seen, for instance, the deeming provision in 8. This is why I'm saying, so when you say it's taken from somewhere else, there's even a deeming provision right at the bottom of page 86 into page 87. I'm just saying that these are things that the members of the committee should be looking at very carefully, because these provisions impact the rights of citizens. And I understand there is an aim, but we also still have to look at the other side of things.
You're looking at page 86?
At the bottom of page, so in sub 8, you will see the deeming, a deeming provision that says anything supplied is deemed to be lawfully given. When you have these kind of deeming provisions, it means that if action is taken in an unlawful manner, persons may not have recourse. I'm just saying we have to be very careful about what's there, which is why, one, I'd asked for the time, but I'm also bringing it to the attention of the members of the committee to go through these provisions very carefully. That's all I'm saying. Thank you.
No, I appreciate that issue. I'm just telling you, I'm not going to interpret the language, but I'm saying I need the requisite authority to have real-time interchange with other jurisdictions. If the jurisdiction qualified, the jurisdiction that have similar comparable respect for the citizens, but I need that information to be interchanged real time, or the registry will be of very little functional relevance to me.
Intelligence gathering.
DPM,
Both for intelligence and evidentiary material.
DPM.
Yeah.
Just to say that where there is a request to share information, an analysis will have to be done just because of how the charter is written and how the courts have interpreted it. So the real-time exchange that you that is desirable in the interest of crime fighting, it can't happen just like that, not with the framework that we have.
Well, I'm not disagreeing. I'm saying that in dealing with this framework, whatever the framework provides, there has to be the need to interchange data quickly on such matters, or it renders the entire thing invalid.
Well, the bigger point is that the entire thing may be rendered invalid. That's the bigger point, really.
Right.
Because it is the way the courts have interpreted the charter provision leave little room for anything that can be done instantaneously.
We have to be challenged, but
every action that is being taken has to go through an analysis.
Well, it tells us going to do it, but it won't be able to give evidence. But if we can get
it's not just in the relation to the giving of evidence.
No, I'm saying that, well, intelligence going to do it whatever they want anyway. I mean, that's the reality of the life we live in. The NSC go and take what they want from us, however they take it from us in real time. And if they choose to give us, they give us. That's a different issue. That's just the reality. But there are situations that is not as clear-cut as that kind of security issue. But is of criminal intent which need to be properly monitored in a timely manner. So I'm not disagreeing that it has to be, I'm not saying examine the protocol, but there has to be a room for real-time interchange of information when dealing with firearms and explosives. Right? The alternative is to have somebody kill a couple of people before you're here. It has to be there. So I'm saying in examining it, look how it can be put in. That's all I'm asking for. There must be real-time interchange available. What protocol is required, I cannot say legally, but there must be.
Chairman, can I ask a question through you, please?
Sure. Yeah.
And I just wanted to ask if the deeming provision, do we have an example of that? Not deeming clause generally, but something similar to this in the rest of our legislation? Is the technical team aware of any other examples like this that could cut?
It's in section 12 of the Financial Investigations Divisions Act.
Okay, thank you.
Chair.
Yes.
Nadine Wilkins, Chair. This provision is speaking of a firearm or prohibited weapon, but the way that the part 2 is done, the FLA would not be the body I'm thinking that would necessarily be exchanging information in relation to a prohibited weapon. It would, I think, more be the Commissioner of Police. When you're speaking of a firearm, which falls within the licensing regime and the enforcement that comes with that, fine. But when we're going into the prohibited weapon, I can't see a scenario where the registrar of the FLA would be providing information in relation to a prohibited weapon. I think that would be the body that would be
Just to point out, though, Ms. Wilkins, that the registrar is really the institute.
Institute of Forensic Science.
It's not the FLA.
On whose behalf is the registrar acting in 6 and 7?
Registrar is the institute. So they would have information on all firearms, not just the...
I beg your pardon.
Right.
But the institute Okay, I beg your pardon.
It's in the project side and
I
legal
thought it would be
side.
the FLA, sorry.
No.
But I still wonder if the police, anyway, all right.
But the police, they said, all their data goes to the institute as well, you know. So that the institute may act on its own behalf, but quite likely it's act on behalf of the police.
Yeah, it wasn't so much that whether the institute would have the information as to the judgment call about what to share. I just wondered if that is, you're proposing that in the institute, in the case of the prohibited weapon, that which is a much more complex situation. But thanks for the clarification, though. But Chair, noting what Director Legal Reform has just raised, that's another issue because the schemes I am familiar with, and certainly that in the FID Act, is for the FID to relate to similar bodies. What you now have is a scheme with the registrar relating to entities that are not similar to the registrar, because the Foreign Law Enforcement Agency is defined as an entity having investigative or prosecutorial functions, which is actually kind of wide as well. So in other schemes, you will have a FID relate to, well, they usually call them FIUs in other jurisdictions, but they are FIDs. So you have an FID relating to an FID. There's a scheme for the FSC to relate to other bodies in their Egmont group, which are the same. So I'm just saying, even this scheme is different.
No, I said SU, we'll have to look at it, make sure we satisfy our country's requirements. I'm just saying to you that there has to be real time. And in the case of our major partner, the institution they refer to is in a sense similar. So if that you do put in there, but they have prosecuting, they have investigating authority. The ATF, you know, the peculiarity of their jurisdiction is that a lot of their agencies which do carry data also have investigative and prosecuting authority. So in that case, which is our biggest source, the institute will be referring to the ATF, which part of their remit is pretty much like the IFSLM. I'm saying I'll await you examining it and look at how we can ensure that the requisite conditions are met, but I have to leave you room to ensure that I can interchange information quickly and efficiently on the especially prohibited weapon. You know, any weapon can be a prohibited weapon if the person do the tricks of trade and get it in space when it is absolutely necessary. All right.
Mr. Chairman, one last question on this clause. If I could direct it to the AG's chambers, is the deeming the same in law in your view as if the clause were to read presumed to be lawful? Are we saying the same thing in law?
But I'm not sure I can answer this in the way you'd want, but the problem isn't so much even the deeming, it's what happens after the deeming. So persons are acquitted, free, discharged. So there is no recourse.
But if I were to presume to be lawful, then there would be, wouldn't it then be for that presumption to be rebutted, which would provide the recourse?
Agreed, except you have some closing words in the same paragraph.
I see.
And those closing words talk about the persons would be acquitted, free, discharged. You couldn't sue. You can't.
Yes, it definitely. Okay.
So it's a little more than just the deeming, right? Yes.
Okay, I will take another look at it, a deeper look at it. Thank you.
An intelligence press operating would have to be cannot be laptop, right? But I don't know if it's the right place for it, so I'd be advised. Drop it. This is it's I'm going to go to 90. Yeah, just I was reading again, section 8, that the SG is bringing attention to, but this is, you have to quit it. Or the stop and search conveyance. 90C, 1C, 2C, without reasonable excuse is added.
But we're questioning the inclusion of without reasonable excuse in this instance. What would be the excuse for escaping or attempting to escape if a constable were to request?
Without excuse, advice. So Richard is asking, why would you want if the constable stops the vehicle and the man escapes or attempts from the conveyance? Why would you have a reasonable excuse to escape a constable?
Chair, if I might, yes, I added that because I thought it might be necessary if there's a situation, for example, where there's some third party who might have been unwillingly being held in the vehicle, that person might attempt to
like a kidnapping kind of thing,
criminalize that person.
And the kidnap gets escaped, they'll be in good order. Yeah.
Yeah.
It's thoughtful. Right.
And the escape is from the conveyance, not from the constable.
Conveyance. Well, it's from the people in the conveyance as well.
Yeah.
Yes, it's
the police stop it and him take a chance to get out of the vehicle and move away rapidly. But of course, he's taking a risk, in my opinion. But it will be a good excuse. Search warrants. Adjusted the piece on being satisfied by information on oath that they are. It says their liability is reasonable. Cause to suspect that an offense under this has been, is being, or is about to be committed. They grant a search warrant or authorizing any constable named. Okay, that's the correction in B. Loans are removed to cause. Again, similarly in 2, I think cause inserted on this occasion. Ninth, 2, port to certain seize conveyancing of premises. Any constable, officer change a member of the Jamaica Defense Force, acting in accordance with the Maritime Years Act. So if you're a member of the JDF, officer of the MOCA, Anti-Corruption Agency. And next line, in the lawful execution of his duties has reasonable cause to suspect that any conveyance of or premises is being used or is about to be used, is added. B, you have A, may without a warrant search to conveyance or premises, and B, on another paragraph is given, which has a number of changes. In the 3rd line on the paragraph is being used or about to be used. And then B2, B is added, a constable who seizes any item under subsection 1B shall issue to the person appearing to be entitled to possession of the item at the time of the seizure a receipt for the item seized. It's important, you know. That was stuff. Firearms. Let's give receipt for seized. The power of constable or authorized officer to require production of firearm authorization. A constable and an authorized officer of the authority, MOCA, sees anyone carrying a firearm, required person to produce to the constable or officer, as the case may be, for inspection, a firearm or ammunition, as the case may be, on the person's firearm, deleted, as the case may be, and B, if such is within any security restricted area, the person's firearm with a special permit with respect to the firearm or ammunition. Pretty straightforward. 90, page 90, still section 93. Three, 4. It's an addition. It's not a square bracket. Get 3, 4, and D. So it is all in brackets. Or addition.
Yeah, yes, it's a new provisions.
All right. Let's make sure it's
3 and 4. Sorry, 4.
Four.
3 and 4. 3,
4.
4 constable authorized to search, right? 4. Where the person is unable to produce an authorization required under subsection 1A or B, we did discuss it last time, was able to satisfy the constable authorized officer as the case may be as to the person's name, address, and identity. The constable authorized officer shall permit the person to produce a firearm authorized within 24 hours hereafter, as such police may be specified by the person at the time. Firearm authorizations will be required to be produced under the subsection 1. And B, if the firearm authorization is produced pursuant to paragraph A, that person shall not be convicted of an offense under subsection 3.
Mr. Chairman, wasn't that in 47?
Think so.
Yes.
Well,
Let me see. Where's the 47?
and I am seeing that we got some written submission now here from.
Yes.
Isn't that the same type of provision
Yes, there's
for the production?
yes. I haven't had a chance to read it yet, but still a submission from the FLA.
But 47.3 is saying, isn't it saying the let me just, person is unable to produce the appropriate firearm authorization. Isn't that produce the firearm within 24 hours? Isn't that the same provision as 47? 47?
Looks like it.
And yes, and then there, well, I had my view, which my view meant is the same, and I see a written submission from the FLA. Is Mr. Darling still around?
Yes, of course.
Yes, Mr. Sinclair.
So Mr. Darling is so quiet. And you have a written submission of several pages here. The thing is what? Several pages, 4 or 5 pages from FLA.
But the contours and recommendations is pretty straightforward. One paragraph. The conclusion and recommendations. It says, in the light of the foregoing, it is the policy of the FLA that carrying a firearm or ammunition in a public place without the appropriate authorization should remain an offense at first instance, and the person should not be given the opportunity to produce the authorization within 24 hours upon providing the person's name, address, and identity to a constable.
And
Yes.
I agree with the FLA on that.
FLA therefore shall recommend that the clause 47(3)(a) and B be removed from the bill.
That would also have, yeah.
Right.
Yes, yes, definitely.
I think that there is good wisdom still in allowing a 24-hour period, notwithstanding. I share the view very strongly that persons who are authorized to carry a firearm should have on their person at all times the firearm authorization. But I think with everything else that is happening, all of the efficiencies, the automation, the use of technology, and we also are moving away from criminalizing person as a first point of response to omissions. I think the 24-hour time frame within which, even if the firearm is held by the constable who's doing the check until such time I think the 24 hours makes sense.
But that's not the last thing you mentioned, Minister, was what to do. Thanks. Good to hear you. The 24, if the constable detains the firearm.
I'm saying if
that would make some sense,
there are
yeah.
different ways in which you can take out right. So if the person, my understanding, gone are the days when the government can say in respect to a license or an authorization that the government is issuing, I don't know that you have it. Government has to be in a position to check whether it has issued a permit to someone, in this case, issue a firearm authorization, given the system that we're putting in place, right? So if they, and if when the system is up and running and you intersect someone who has a firearm that is marked in the appropriate way, the system through its automated automation should allow for the checks to be made, unless I am misunderstanding what it is that is being put in place. So that if the firearm is not marked in accordance with how it ought to be marked, then you know how to treat with it, deal with it. If it is, a check can be made. If the person has ID other than the license, it can. If he or she doesn't, you can also, I don't see any harm really in providing the 24-hour within which to provide the authorization, given the system that is being put in place.
That was fully ventilated out there. I'm not sure if you're there. In privately the same lines. And that's why this was put in, but there was a reservation about the 24-hour without some accountability, which Senator Sinclair raised. And you did so that there was a suggestion, and it was the contention was that a firearm can only be stored at certain stations, that the weapon should be detained for 24 hours, and then the owner reports to the nearest station that they go to with the authorization, and then it's returned. That was a compromise, but it was not absorbed because of another technicality, which I don't think was that substantial. But there are circumstances where you could, in fact, if the person is a criminal, they will steal the firearm and the car and the identity. And then you have a problem. That's the exception that was brought. So, but I do think for a licensed firearm holder, 24-hour, there's a means of providing them a relief.
So DPM,
and that's why the idea of
this
it.
Doesn't, a 24-hour grace period doesn't mean that a police may not detain a person where it is appropriate to do so.
Oh, well,
in that time frame. And that person may have to reach out to a third party to have it fetched. All it is saying is that before the offense kicks in, you are given an opportunity.
Oh, that we agree, you know.
Right.
I think there was a common agreement, the Minister. The issue of not necessarily detaining the person, but detaining the firearm for 24 hours while the person brings the authorization.
I hear that. I was going beyond retaining the firearm until such time. I'm saying putting aside even retention of the firearm in an appropriate case.
Yeah,
the police can also
reasonable suspicion, they can
an appropriate case.
They can do some reasonable suspicion that the person is not the person. No, the issue of the 24 before the offense kicks in, I didn't see it as a challenge, but that the firearm must be under the control of the police until the 24 comes in. That's where I was.
Yes, I am with you. I'm with you on that.
I still voice my reservation, and what I see as the position of the FLA, which is, well, they had not said it on the last occasion, but I had said it that I think that they should always, the person should have their firearm authorization with them. And if they do not produce it, then they should be, until they produce it, they should not be allowed to Just give my identity and address and
Oh,
go
they
there.
have to, they should not have the firearm and they should not be allowed to keep the firearm.
And they should not be allowed to leave either.
All right. You're
Get
going
a third person to bring it.
all
I
right.
suppose it will happen to them one time and it won't happen again, Mr. Chairman. But that is my position, and I don't
No, I
see
think we are getting
anything that can influence me to move from that position.
no, I think the two things don't contradict each other, Senator. The idea that you are allowed 24 hours for the offense to kick in, I think is what Minister has raised. I agree with that. But we have to ensure that the person and the firearm is under control until that comes in. So as I said, if you wish to detain the person at the station, they can call home and get someone to deliver the firearm license to X station and say, yes, it is confirmed then. Or follow them home. Or follow them.
Sorry, Minister, I just wanted to say, I think we always need to remember that a firearm has been echoed in many of the meetings before the Joint Select Committee, that a firearm is a weapon of mass destruction. This isn't a motor vehicle. This isn't a jockey license. This is a firearm that contributes to the crime. The high crime rate in Jamaica.
Killing self-defense or killing crime.
Exactly, and I think that each firearm holder should be held to the highest standard. I don't think, even though it has been said that there might not be any harm in allowing this 24-hour grace period, I think it sends a message, and we need to send a message that if you're going to own a firearm, you must be held to the highest standard.
Right. So I think there's no, what standard say? I'm saying detain the firearm.
Sorry, everyone. This is Alana One List from FLA.
Yeah, FLA or JC? Yes, sir.
FLA, I'm legal officer from FLA.
Right, so
let me just weigh in there, DPM. May I just weigh in there? So we're putting in a process of deep vetting for persons. And it is my hope that after the process that is being legislated is put in place, that it will be utilized. So this getting a license is not a starting point for someone, because once a person has been authorized, someone, i.e. the FLA, would have already done an assessment that this is a person who is fit and proper to be authorized to carry a firearm. What we are providing room for is the human element. It does not mean that they will not be held liable.
We're in agreement, the idea is what level of control you put in. Senator Sinclair suggests we don't have to go back there. And deep vetting also means in the modern world of technology, there's no deep identity stealing. So you have to prepare for all activities. And the idea, the weapon of destruction is the firearm. And I'm suggesting we detain the firearm.
And I said, I am in agreement with you on that, because that's a gap that we're trying to address.
The suggestion is by Senator Sinclair that you should maybe detain the person as well, which is another standard which still allows the offense to be kicked to 24 hours. So if you detain the person, they'll have to find somebody to verify for them at a police station that they are they, or who they say they are.
Chairman, I believe the power of detention exists. It doesn't have to be legislated here. Once the threshold is met, if you have reasonable suspicion that the person has committed an offense, or if it is necessary to prevent the person from committing an offense, the police may exercise the power to detain. That power is provided for at the highest level in our laws. It also exists at common law.
Okay, so we'll insert a clause this evening unanimously. Senator Sinclair, where a clause will be there that the firearm will be detained. And for now,
retained.
Retained.
Yes.
Not detained. All right. is a living, cruel creature, so we detain him. But the firearm will be retained until the person prove their identity otherwise, and we can follow everything else. If there's reasonable suspicion, they have the right to detain the person.
It's not their identity that they are proving, is my understanding, is that they are going to be allowed to fetch and carry the license if nobody
Yes,
else
but
is
if
able to do so on their behalf.
If there's a reasonable suspicion that the identity is not correct, it doesn't
Well,
detain the
any of the
person.
many offenses, it doesn't have to
Right.
relate to an issue of
Sentencing
identity.
there, we call it, it's half a cake, and with half a cake is always in today's dieting is not a bad cake.
Minister, may I say one thing? We have done some
Detain the
research.
firearm.
We have done some research on this matter, including the United States that have persons have a right to bear arms. And we have not found any provision where persons who have a permit are granted a permit and stopped by the police and requested to provide same. And when the police stop an individual and the person has a firearm, the first presumption in the law is not that the person is licensed. You know. The presumption is that the person has an illegal firearm. The rebuttable presumption rests on the individual to satisfy the police that he has a license for that firearm.
With all due respect, Mr. Dallin, again, let's look on the framework that we're legislating. So, and it's so important that we make the mind shift. This law creates a dual system of dealing with the regulation of firearms. On one hand, which already exists but is being strengthened, is the licensing authority, the FLA. All right? There are provisions in relation to the importation, even manufacture. We're not a manufacturing country, but the importation, duty placed on those who are importing, requirements for the marking of the firearm, for the ballistic testing, for the signature, all of that for a database to be put in place in relation to the firearm, even before it is issued to someone for traceability. And then there is the authorization process that is being legislated and beefed up, right? Taking into account the loopholes and the gaps and all of the problems in the system. So that you are telling me that we are wasting our time legislating this very sophisticated system that ought to be implemented with ease and enforced with much ease. And then we're going to have the same set of problems. This is not about letting our guards down. Whenever we improve system, we have to adjust to take advantage of the improvement. So we lessen the burden both on the entity and on the people. Otherwise, it makes no sense.
We had an agreement and said detain the firearm, but in the issue, just bear in mind, we did discuss this extensively, and the point is that the more sophisticated our system becomes, so to the person who will escape it, so the more sophisticated one as well.
Indeed, Chairman, indeed.
That is why you have to be careful, still have to sum up.
Right, but from a policy perspective, it's not about letting the guard down, but it's also about a differentiated treatment in respect of those persons who have been betting. Whether the firearm is in the system and authorized or not, it is still prone to cause the same level of harm, depending on how it's used.
As I said, what I used the term was a minimal level of service to those who are law-abiding, but you have to have your guardrails have to remain very strong and defined. And it's a question of fire sets. In this point, I'm willing to suggest we retain the firearm until it's produced. There could be cause one day to detain the person, but you have to. There's still room without legislating it to do so.
This point out as well, though, Minister.
In other words, if the policeman meets a person without his license, who he knows, then he would have to detain him. If we put in law that he must be detained, then he'd have to detain him. So I'm suggesting, Senator, that we detain the firearm. So if it is brother, friend, just a piece down the road, him still have to keep the firearm and go down the road and bring back his firearm. That's the law. But you would not detain him as a person. If you have reasonable suspicion the person is unreasonable, can mean anything. You don't know it. It's coming from Coming from Montego, there are downtown Kings, say, figure, boy, me not trust the body for me so well. That's wrong, but you may just do that.
Just to point out, Minister, if we're retaining the firearm, the clause that 4A has written for the person to identify where to present their authorization could not necessarily remain. You have to make that change accordingly.
You would have to, you just have to go there and
It goes back to wherever
if
it
the
was.
police
that it was
verify the
retained.
authorization, you can in fact get it done wherever it is. All right. So that's what will be added. The detention of the firearm, which is the weapon of destruction.
It's a question. I don't know if there's a provision for it, Mr. Chairman. If you are going with that, as I said, I have my view, which I don't think that I'm convinced in changing that view. But if the person caught in this scenario gave to the police a false name and address or some wrong information, is that an offense? Mr. Richards?
If the police release him, first, if the police have reasonable suspicion that the person is falsifying anything, they can detain him, which is what I think your colleague minister was suggesting.
That's provided for in.
But there's also provision for prosecuting them if they escape that initial thing. If they
A
give
person refuses to comply with the requirements.
false information.
Where's that, Mr. Richards?
94.
90.
Clause 94, page 94.
Clause 94, sorry. 94.
Same here, pause constitutional respect of concealed firearm.
Four, 94.
94.4.
94.4, where a person refuses to comply with a requirement made to that person, the concept, or fails to give, okay, the person's true name and address. All right, thank you. Thank you. Sorry.
That's some fallback. 95, the next change we have is a 95. We have a person arrested for an offense on the act or added is detained on reasonable suspicion of having committed offense under this act in the firearm found that the person at the time of the arrest, the time for the alleged commission of the act shall be retained by the police. As such time as the person released or legal proceeding against the person in respect of offense or final disposed of. So in fact, we are defining the positions for detention. So there's room for detention in this retention of the firearms as well as the person. Continuing, the next set of changes come back. 3B, no, 2A, there's a word reasonably is introduced in line 4. And then going down to 3B, acquitted and is approved that the person is the term lawful owner is removed and hold of a firearm authorization in respect of is replacing lawful owner. 4, they again introduce where an investigation under subsection 2 concludes and no legal procedure have been instituted against a person in respect of any offense mentioned in subsection 2. So the word an investigation under subsection 2 concludes is introduced. So this within 14 days after the conclusion of the investigation, the firearm should be returned. So the word addition was within 14 days after the conclusion of this investigation. And we remove instead of lawful owner, hold of a firearm authorization, replaces lawful owner. And no holder is proved shall be transferred to the authority for disposal. At the end, 102 is replaced by 103. Then we go to forfeiture. All right, we'll finish. We'll take a long, but we'll finish. It's 4:45. We'll just finish at 5. Thank you for your forbearance. Let's see what we can do. Forfeiture of firearms and ammunition 96.1 applies to forfeiture and added to this pursuant to section 95.3 and 3A. And then we go to 96.4, which is totally deleted, and 54 subsection 5 is left as 4. No, part of 3 is renumbered as 4. Subsection 6 is renumbered as 5. 94, including we go to the part 9, provision in respect of offenses. This holds the margin has been deleted, and 97 A is deleted. And we A and B, and we go to fixed penalties in 97.1. And here is a long new section. Wait, it's entire 3 pages. So read this on this one. The authority may serve a person with a fixed penalty notice if the authority has reason to believe that the person has committed an offense to which this section applies. The offense to which this section applies are an offense A under offense under section 77.2, failure to display a license required, or section 78, contravention of terms and conditions of firearm authorization. I remember this was a long debate. It's a whole new section. Using fixed penalties, Minister Ford, no, in fact, taking your philosophy through to drafting that individuals who are law-abiding citizens who breach may be subject to a different regime of accountability than those who are illegal, and the fixed penalty was brought in, which applies to licensed firearm holders here. B, any other offense prescribed under subsection 11 within brackets, I expect it should remain. 4, a fixed penalty notice under the section is a notice in writing.
Can that part of the bill be put up on the screen, please?
Right, what again, Minister?
Just asking that the screen share that part of the bill.
Yeah, fixed penalty.
Right, just
yeah.
4 here, okay.
Yeah, 4. 97, the margins, the title in the margin were deleted, and the first section of 97 was deleted. Now you have fixed penalties, 97, 1 through 2, and you have 4 now. It's it's 4, 5, 6, 7. Fixed penalty replacing a lot of what was criminalized for the licensed firearm holder. 4, when it is served, the opportunity to discharge any liability to the conviction of an offense to which this section applies by payment of a fixed penalty under this section. 5, a person served with a fixed penalty notice shall not be liable to be convicted on offense to which this section applies, in respect of which the person pays the fixed penalty in accordance with this section. B, the requirement in respect of which the offense was committed is complied with before the expiration of the 30 days following the date of the fixed penalty notice referred to in subsection 4, or such longer period as may be specified in this notice, or the date on which the proceedings are here, whichever event last occurs. Section 6, or clause 6 really, where a person is served with a fixed penalty notice under this section in respect of an offense, proceedings shall not be taken against any person for that offense until the end of the 30 days following the date of the notice, or such longer period as may have been specified herein. 7, in subsection 5 and 6, proceedings being any criminal proceedings in respect of an act or omission constituting the offense concerned and convicted shall be construed in like manner. 8, the payment of a fixed penalty under this section shall be paid to the collector of tax. I think there was a debate about FLA. I think it will remain collector of tax, KJ. Specified person under subsection 11, and any proceeding or certificate that payment of a fixed penalty was or was not made to the collector of tax by the specified in the certificate shall, if the certificate proposed to be signed by the collector of tax, be admissible as evidence of the facts stated therein. 9, a notice under subsection 1 shall A, give such particular of the offense, alleged as are necessary for giving reasonable information of the allegation. B, state the period which, in brackets, whether 30 days or a longer period, in which by virtue of subsection 6, proceeding will not be taken for the offense. 2, the amount of the fixed penalty and the collector of taxes to whom and the address at which it may be paid. A, require the person in the event of that fixed penalty is not paid within the period specified pursuant to paragraph B, to attend before the court having jurisdiction to try the offense, to answer the charge on such date as may be specified, being a date not earlier than 10 days after the expiration of the period specified pursuant to paragraph B, and the requirement shall constitute a summons for the entity to attend the court to answer the charge if the fixed penalty is not paid within the period specified pursuant to paragraph B. 10, in any proceedings for an offense to which the section applies, no reference shall be made for the conviction of the accused, the giving of any offense under this section, or to the payment or non-payment of a fixed penalty thereunder, unless in the course of the proceedings or in some document which is before the court, in connection with the proceedings, reference is made by or on behalf of the accused to the giving of such a notice, or the case may be to such payment or non-payment. 11, the minister may by order subject to affirmative resolution make provision as to any matter incidental to the operation of this section, in particular in such order may A, prescribe the form of notice under subsection 1 and the collector of tax to whom a fixed penalty is paid. Hopefully we can get it on the printer of the police. 2, the nature of the information to be furnished to the collector of tax on any payment. And 3, the arrangement of the collector of taxes to furnish to the authority information with regard to any payment pursuant to a notice under the section. 4, the amount of the fixed penalty. And 5, without prejudice to any offense mentioned in subsection 3, any other offenses under this act to which this section shall apply. B, make provision for the cancellation or variation of fixed penalties. Yeah, that's a fixed penalty regime for a number of issues related to the lifespan order. I express other much. I hope we'll be able to get those fixed penalty form on the smart check program of the police force, so it can be sent through the electronic system to the tax office and through the courts, as we do for ticketing. And that's where we need the ID now, Minister and Senators. The national ID is verifiable. Evidence obtained from
sorry, Mr. Question.
Yeah.
In the event that the person does not make use of the opportunity to pay at the collector of taxes and then has to be found and placed before the court, right?
Yeah.
Or not, probably I should check, let me amend it. If the person did not make use of the opportunity to pay at the collector of taxes, but then goes to the court to make the payment,
yes,
it happened to become a summons. Is the penalty increased? Is there an what's the situation?
It's not named here, I think, but we'd expect the court to increase the penalty. If they don't increase the penalty, they're gonna flood the court as they're doing it with the ticket existing.
Right. So
it will be at the discretion of the parish judge now.
Yeah. All right. So the fixed penalty fees, those are going to be contained in the regulations.
Yes. And the minister can change them by affirmative resolution.
Okay. And in the event, as I said, the regulations will deal with that aspect of it, about the potential for doubling up the fees or something.
Yes, because if they don't, but I said if they don't, then everybody will go to court.
Right. So that will be contained in the regulations.
That's correct.
All right.
So it's a 98. me read 98 for me. 98.1. Evidence obtained from controlled delivery operations. Go ahead.
But just to point out that the CPC had indicated that she probably needs some additional particulars for us to be able to expand the section. So this would have come from the JDF as well. So 98.1 in this section, A competent authority means the Commissioner of Police, the Chief of Defense Staff, the DG of MOCA, or the Commissioner of Customs. Controlled delivery operation means the technique of allowing illicit or suspect consignments of firearms, ammunition, or prohibited weapons and other related materials to pass out of, through, or into Jamaica with the knowledge and under the supervision of a competent authority, with a view to identifying persons involved in the commission of any offense under this act. 2, evidence obtained by a competent authority through a controlled delivery operation shall be admissible in evidence in proceedings for an offense under this act. And I'm not sure that JCF is still in the meeting.
The intent of this really is.
Yes, CTD Richards, we're here.
That's right. You may should explain. This is really a sting operation.
Yes.
And therefore, no one should be held accountable. That's right. You want to explain some more?
Yes, Chairman. Well, we had discussions with the technical team, and we had put forward a position where we think that this provision should be further developed to allow for what is called clean, or referred to as clean control delivery, and the JDF in their submissions did mention it. So where we intercept an illegal firearm, we want to be allowed to be able to take out that illegal firearm and replace it with, in a sense, a dummy item, right? And then allow the shipment to continue to its final destination. But of course, when it reaches its final destination, the person who receives it would now be in receipt of the dummy item as opposed to the illegal firearm. And that may raise, well, that will raise issues in relation to possession, being able to charge them with possession of the illegal firearm when what they actually possessed was a dummy weapon, essentially. So we were in support of the JDF submission in that there should be a provision to prescribe that any such removal of the illicit weapon and replacement of it would still, the law would still find that the person who received the item was in possession of the illegal item. So I believe that we're trying to work on providing some more instructions to the CPC to see how that can be developed further.
This is that clause that should have been there from day one. So I will accept it, but ask for the work to be done. So it's quickly, the CPC is kind of a clear picture of what the mischief is and what we intend to correct. Or whether not only the mischief, the work of the police in correcting all these problems. But you understand, members, right? Implication of this. 99, circumstances that may be regarded in determining fines and sentences. It's the place to put this control delivery operation, though.
Oh, that's the draft.
Right?
That's
yeah, but this one is. I don't know if it's this to the right place, right?
But it is miscellaneous.
Maybe better off in there. No, maybe better off in the funds.
The item.
All right. We'll discuss it. I was raising the issue, members, that whether this and we'll have to have this, the technical team, the policy will have to review it and speak with the AG and CPC, because I'm not sure this is it. As a layman, this is the best place for it. That's right. This is a miscellaneous section. I think this should be. All right. Circumstances that may be regarding determining fines and sentences, 99 no. 1, and determine the amount of any fine to be imposed in respect of an offense on this act, a court may have regard to, in any case of a body corporate, the nature of the business, size of the business concerned, including the level of profit or total revenue generated by the body corporate, B, the nature of the offenses committed, C, whether the offense was committed for the benefit of a criminal organization or was committed for profit, and D, any other factor that the court considers relevant. Seems pretty straightforward. And then 2 of the same 99, in determining the severity of any sentence and added of imprisonment, in respect of which a minimum sentence is specified for an offense on this act, which shall have regard to the list of items given to which B2 added, an area declared to be a zone of special operations and the law reform zones of special operation, special security and community development measures act, or 3, in an area which a declaration of state of public emergency enforced under the Emergency Powers Act. Proceeding in relation to persons under the age of 18 years. That's section 100. Nothing changed there. Goes to 100. Nothing more is changed until we get to schedule 101. Punishment, proof, and record of respect of offense. 6 schedule. Item 8. Where's 7?
Should be 7.
This is 7.
Should be 7.
Not 8. It's an addition where in any case a person charged with an offense under this act asserts as a defense to the charge the fact of a firearm authorization permitting the activity concerned, it shall be for the person to prove the existence of the authorization. We'll take this and pause for this evening at part 9. The last paragraph for the evening. 102, obstruction. A person who assaults, obstructs, hinders or resists or uses any threatening language to an authorized officer executing any function under this act commits an offense and shall be liable on summary conviction thereof, therefore, before parish council court to a fine not exceeding $1 billion or default payment of that fine to imprisonment for a term not exceeding 12 months. Let me thank the members for responding and holding to Zoom until 5 o'clock. But we are going pretty good now. We have made 2 commitments this evening. We have to discuss 99 with the technical team and better instruction to CPC, also into the control delivery, 98. And I think there was another issue we were to
sharing of information.
Sharing of information, SG officer look at to ensure we will not breach our constitutional right, but provide the kind of protocol required to ensure that we can carry out the instrument law enforcement activity effectively on time. Let me thank everyone. I think the next meeting is scheduled for Anila.
July 7 at 2, sir.
July 7, that's a long way off.
Just a week, sir. Oh, so it will give CPC time to fix.
Anila would like. We have been occupying CPC's time. She's coming under pressure with other legislation.
Yes, because we have some other joint select committees that are scheduled to meet next
week. And we have to get we're going to lock some more days. If it's the 7th of July,
I actually thought we had adjourned to Thursday and not today, Chairman. For some reason, there seemed to be a little confusion there, but I think persons need to understand that it's the same set of technical staff in the OCP, the AGC, and the LRD that are working on the various pieces of legislation. And so while each ministry may have its priority, it really bottlenecks at a certain point. And until the resources are improved.
That's right, Minister.
Including the parliamentary space, i.e.
including the elected ministers as well.
Indeed.
No, but part of it is just to get this. One of the things that I tried to do, Minister, is see if we can finish something, because when you finish it, it also clears the space a bit better. Okay? While it's there, it's always kind of a hurdle in there. To the extent we can go through this quickly, it would mean the space for you to focus on a number of priorities is easier. Multiple priorities often lead to longer delays. And I know that on this particular bill, it is the CPC working on it. The Chief Parliamentary Counsel herself. I appreciate it. Let's see if we can tie the people.
Sorry, Mr. Chairman, before you close, the JCF did have a comment in relation to 1018, the reverse burden provision. Should we hold that until the next meeting?
101 what?
1018, the reverse burden.
Yeah, well, you could hold that, 1018.
Very well.
Send it in, but the Minister, I know you're out there. Thanks for coming on the Zoom.
Yes, DPM, I'm out in
And
constituency.
I appreciate your contribution all the time. You know, I need you there at my right hand. It's matter. But
We will get it done. However,
both my
torturous the
Montego Bay
process.
champions, Senator Sinclair coming in from Montego Bay. We should be able to go through this.
Senator Sinclair came in for a Zoom meeting,
No,
DPM.
no,
I shall have to investigate.
No, I'm in office. I'm in my
Okay,
office.
because I would have to launch an investigation into that.
Yeah.
Mr. Chairman, if I could just ask for your indulgence and the committee's indulgence, I think the next meeting you have, I will not be present physically, and I would crave your indulgence to attend virtually.
We're trying to work much of what we have left virtually until the last meeting, Senator, because, you know, or hybrid at least. But I said I'm not going to guess the number of meetings, but I'm trying to get this through this month, next month. So I'm asking Anila to hold another 2 days so at least we get through this phase of it quickly. So you have July 7th. I don't know what days are the nearest date of that, Anelia. If it's Monday, Tuesday, Wednesday, we should be on break then. But please lock up 2 more days quickly from it here, Anila.
And July 7th is in the morning, Chair, or
It's
afternoon?
2 p.m. Senator.
Thank you so much.
Right. Minister, I know you won't be, I will not get a harsh to come in, but Minister, 4th week Parliament will convene tomorrow.
Let's speak off the record on that matter, DPM. I'll call you. You would have seen a missed call from me. I'll speak to you.
Okay. I'm on silent, so I apologize. I will have to put you on that it can ring through somehow. Yeah, but sometimes the phone doesn't work as well.
Yes.
Okay.
All right, so we move for the adjournment.
And we adjourn until next July 7th. But again, thank everyone. Have a good evening, despite of the chairman pulling you up on Zoom all over the place.
Thank you, Chair.
Look out for my call, DPM.
Yes, 579-7311.